Good day to Dr. Aida. And today we are from Saranyaa and Co. Representing our client, Mr. Jimin. Mr. Jimin is the accused of drug possession before the magistrate, Jitra's magistrate court. The first charge against our client is that the possession of cannabis, which amounts to 0.16 gram, which is chargeable under Section 6 of Dangerous Drugs Act 1952 and also punishable under the same act. The second charge against the client is that the self-administration of drug, which is can be chargeable under Section 15(1)(a) of the Dangerous Drugs Act. Our client has been pleaded guilty so that the magistrate scheduled a fact finding and the sentencing proceeding for today. Firstly, we would like to tell about our client's background. Our client has been completed his PMR from SMK Jitra. He also obtained a very good academic results in his PMR examinations. He did not continue his studies after losing both of his parents in a road accident. The client was working as a food delivery rider and also helping his sister to run a restaurant. Before the court passed the sentencing to our client, I think we hope the court should take into consideration a few mitigating factors which will be applicable to our client. The first mitigating factor will be the age factor. For our client, the first factor that the court take into consideration is the age factor. The client Jimmy is just 20 years old young man. According to Section 2 of the CPC, a youthful offender means a person convicted of an offence punishable by the fine or imprisonment who is above the age of 18 and below the age of 21. When we look at the case of Teo Siu Pang versus PP, it is tried law that in the case of young offenders, where there is no conflicting regarding public interest and that of the young offenders. The public have no greater interest than that young offenders should become the good citizen. Based off the above mentioned case, it is clear that when comes to a young offender, the court always shows the leniency in sentencing to the accused. So the age factor of our client is more important for the court to take into consideration before passing the sentence. The second mitigating factor will be the character of the accused. Referring to the client here, his sister has testified that our client is having a good interest and talent in the business field. This shows the positive character of our client who can run his own business in upcoming years. Apart from that, when looking at this academic achievement of our client during his schooling, he also has scored 8 A's in his PMR. It shows that our client is also being a good student. He may also can pursue his studies in business field, which will enhance his talent and qualification in future. According to the case of Winston Raja versus PP, the court held that the healthy activities of the appellant had participated in before reflects his antecedents and character to a certain extent. So that, based on the client's good character, the court should take into account this factor before passing the sentence against him.
Okay, so today I'll be talking about plea of guilty for the case of Jimmy. So a plea of guilty is a strong mitigating factor as it saves time and cost. The court in assessing the sentence should consider the plea as a mitigating factor since it avoids a lengthy trial and also saves time and inconveniences for many. This can be supported by the case of Sao Su King versus public prosecutor, where the sentence of the accused has been mitigated despite the offence committed by the accused is a grave offence as it saves the country a great expense of a lengthy trial, save court's time and cost of the parties involved in the case, particularly the witnesses. So in relating to the case of Jamie, his plea of guilty serves as a powerful mitigating factor, demonstrating his acknowledgement of wrongdoing and acceptance of responsibility for the charges brought against him. By pleading guilty, Jamin shows remorse for his actions and a genuine desire to cooperate with the legal process.
Continuing from my fellow firmmate's explanation regarding other mitigation factors, I'll be explaining regarding our client's remorse and also his willingness to accept responsibility. So by changing his plea to guilty, our client has established that he is aware the consequences of his action and he is committed to making amends. And through his stable employment and also helping his sister at her shop, it suggests that he is a responsible individual, and this is in contrast to the typical behavior of substance abuser. So with this sense of duty that our client possess, it is obvious that he feel compelled to mend his way. So regarding the remorse part of my client, our client has asserted that he consumed cannabis was only to manage his blood sugar level to a more manageable way. and there are legitimate clinical studies to back up his statement. However, since he is aware that using cannabis is against the law, he chose to enter a plea guilty, as it is morally a correct thing to do, regardless the health benefit of cannabis. And this can be seen through the case of Raja Izzuddin Shah versus public prosecutor, whereas in this case, the defendant admitted guilt and have been found guilty of assaulting a public officer, and later he apologized to the victim. But due to this, he received a 3-month prison sentence. However, the court held that since that he showed that he was repentant and remorseful of his act, his sentence was reduced. And with that, I think the remorseful and the responsibility that our client possess should be a mitigation factor to be considered by the court. Mitigation factors that can be considered would be previous criminal records, and according to our client's criminal records, there were 2 offences that we can see. The first one would be he was previously detained under the suspicion of stealing a motorbicycle. The second would be cannabis possession when he was 17 years old, and he got 2 years placement under the welfare department supervision. Regardless of this, for the first offence, there was no charge brought against him, and the rules of innocence, which is proven until guilty, is applicable to our client. Moreover, the first offence was unrelated to his current charge, and it shouldn't be detriment to his mitigation pleas. Followed by that, during the course of 2 years observation, he received a certificate of good conduct as he showed an exemplary behaviour, and for his present and his past employers, they also attested that he was on good conduct during the course of employment. And this is further back up through the case of Muhammad Azmi J, public prosecutor, versus Mark Cording in 1983, whereby the accused was being released on a good behaviour bond, as the court held that it was a substantial mitigating factor. And this particular matter should be applicable to our client in his mitigation pleas.
So next, I'll be talking about the other factors where drug possession and the weight of drugs matters. So in the case of Susainathan versus public prosecutor, in this case, the accused pleaded guilty to charges of possessing 0.07 grams of drugs and failing to produce an identity card when requested by a police officer. The accused had 3 prior convictions for different offences. During the plea of mitigation, the accused mentioned earning about 850 ringgit per month as a sweeper and supporting his family with RM 400. The magistrate initially sentenced the accused to 4 years imprisonment and a year of police supervision for the drug possession charge, and a fine of RM 300 for 3 months for the failure to produce an identity card charge. However, upon appeal in this case, since the accused had only 0.07 grams of drugs, it suggested that the drugs were for personal consumption. It was held that in considering the small amount of drugs involved and the accused guilty plea, a non-custodial sentence would be more appropriate for the drug possession charge. So, in relating to the case of Jining, it is important to highlight the similarities in terms of the small quantity of drugs involved, which is 0.16 gram, and it was for his personal consumption rather than for a drug trafficking. Considering Jimin's type 2 diabetes condition, it is important to note that he believed cannabis could lower his blood sugar levels. This suggests that his possession of cannabis may have been driven by a perceived medical benefit rather than a recreational intent. Given these unique circumstances, it can be said that a non-custodial sentence or rehabilitation-focused alternative would be a more suitable and fair, aligning with the principle of justice.
The sole purpose of probation or rehabilitation is to provide a certain category of persons a chance of reformation. It is true that in strengthening their own moral fiber against their existing degeneracy, most of the offenders need nothing more than sincere advice and help from the other members of the society. And such advice and help is what the probation seeks to provide. The deterrent aspect is not completely ignored. The offender is not completely released, but the sentence of punishment is merely suspended and is made revocable if the prescribed conditions of probation are violated by him. This may have a deterrent effect upon the offender released on probation. Probation is particularly useful in the case of youthful, as it saves them from exposure to the atmosphere of jails and from the stigma attached to the imprisonment. A youthful offender is defined under Section 2, Subsection 1 of CPC as one who is above the age of 18 and below the age of 21. Furthermore, in the Tukiran bin Taib and PP case, it was held that it is very desirable that a young offender who is between the ages of 17 and 21 should be kept out of prison, and if possible, it would be more beneficial to him and in the long run to the community at large to send him to an advanced approved school. So in our case, Pak Jimin is 20 years old, therefore he is a youthful offender. By considering this fact and his personal circumstances, we can pray to the court for an alternative sentencing, which instead of going to the jail, the court may impose probation on him. Besides that, we also need to take into account about his sister, the only family member that he has, who plans to send him to a private drug rehabilitation center and later also get treatment on voluntary basis at Clinic Cure and Care AADK. Next is about gap principle. Clean record of the offender since the last conviction is a mitigating factor provided that the last prison sentence is already terminated and some long duration of time has lapsed. Triviality of the past offense is also taken into account. In Zaidun Sharif MPP, the accused had appealed against the sentence of the magistrate court, which imprisoning him for 9 months for the offence of possession of cannabis weighing 0.04 gram. However, the appellant had a previous conviction for an offence under Section 379 of the Penal Code in 1986, for which he was sentenced to 1 day's imprisonment and a fine of 1,000 ringgit. It was held that since there has been a 10-year gap in the applicant's criminal record, it is a good mitigating factor. Besides that, the judge also stated that a previous conviction is to be taken into consideration only if it is of a similar nature with the current charge. This case also laid out the principle of when where the previous offences were trivial and committed in the long distant past, the court will normally disregard them entirely and treat the offender as a man of previous character. So in the present case, Pak Jimin was brought to the court for children for the same offence, that is possession of cannabis, when he was 17 years old. He then was placed under observation of welfare department for 2 years. This means that the gap between the previous and the present conviction is only 3 years. Thus, the application of gap principle may not be a good mitigating factor as it requires a long duration between the two convictions. However, in reference with the Zaidon's case, we can still apply this principle on the basis that the previous offence was trivial, but still we need to straighten this with another mitigating factor in order for the court to order a lenient sentencing.